Okay, let's dive into this. A courtroom trial. It's fundamentally this search for truth, right?
Exactly, but it gets really intense when you have completely different stories about the same event.
That's the drama, isn't it? You're always left wondering, okay, which version is the real one, if any?
Absolutely. And for this deep dive, we're looking at one specific hypothetical trial. We've got the witness statements, the key courtroom moments all laid out.
And the big problem here is 4 witnesses, same event,
Yep.
but their stories all over the place.
Yeah, and it's the jury that has to somehow sift through all that mess and figure out what actually happened.
Which sounds almost impossible sometimes. Memory's tricky.
So tricky. Bias creeps in, perception differs. You know how it is. 2 people see the same crash, 2 different stories.
Right, so let's paint the picture. First officer on the scene sees blood where their victim is.
Uh-huh.
And this officer notes the accused is acting, well, strangely.
And strangely itself is subjective, isn't it? Especially under that kind of pressure. What's strange, what's shock?
Good point. And here's where the officer's testimony gets really, really interesting. He sees the blood, notes the behavior, but admits he never actually saw a weapon. He just assumed there must have been one, given, the situation.
That's a classic assumption trap. Confirmation bias, maybe? Looking for things that fit a preconceived idea?
Could be, and you have to wonder if he assumed that, what else might he have assumed?
Exactly. It potentially colors everything else observed from that point on.
Okay, so witness number 2, the neighbor. Initially, she swears she heard yelling around 2 a.m. Seems specific.
Pretty specific, yeah. You'd think that's a solid detail.
But then, later on in her testimony, she changes it. Says it was actually 3 a.m.
That's a significant change. An hour's difference. Memory's definitely pliable, isn't it?
And the defense, of course, they pounce on that.
Natural.
I'll suggest, well, maybe she saw news reports later, got the time mixed up. They're planting that seed of doubt.
Trying to show she's maybe suggestible or just unreliable. How did she take that?
Oh, she got really defensive. Snapped back, basically. I know what I heard.
That certainty. People feel very sure about their memories, even when they're demonstrably wrong sometimes.
It's that clash, isn't it? The feeling versus the science of memory.
Yeah, and the jury's sitting there thinking, okay, she sounds sure, but there's this inconsistency. How much weight do we give it?
Exactly. Okay, moving on. Forensic expert. This is the science part, supposedly objective.
Right, the hard evidence. What did they find?
They found the suspect's DNA on the victim's jacket.
Okay, that sounds pretty damning on the surface. DNA connection.
Seems strong. But the defense immediately has a counter.
Let me guess. Contamination?
You got it. They raised the possibility the sample got contaminated somewhere along the line, questioning the handling, the chain of custody.
Standard defense tactic, but a valid one if there are procedural questions. It forces the prosecution to prove the integrity of the evidence trail.
Right. It makes the jury think not just what was found, but how it was found and handled.
Any small doubt about the process can ripple outwards.
But then the prosecution hits back with something else. Something pretty strong.
What's that?
Suspect's fingerprints. Found inside a glove at the scene.
Ooh, inside. That implies wearing it, doesn't it? Or at least handling the inside. Seems more direct than DNA on a jacket.
It feels more direct, yeah. But here's the slight weirdness. DNA is on the outside of the jacket.
Right.
Fingerprints are inside the glove.
So not quite a perfect match in terms of, the narrative they suggest. One implies contact, the other implies wearing something found there.
Exactly. They both point towards the suspect being involved, maybe, but the specifics, they don't perfectly align. It's a bit puzzling.
And that discrepancy itself might be something the jury picks up on. Does it strengthen the case because there are 2 types of evidence? Or weaken it because they don't tell exactly the same story?
That's the question. Okay, final witness we're deep diving on. The victim's best friend.
Ah, the emotional testimony.
Very emotional. She talks about how the victim was always, super careful, never walked down dark streets, avoided risks.
That kind of testimony really humanizes the victim for the jury, establishes a baseline of normal behavior, making the crime seem even more out of character for them.
Definitely. But then the defense reveals something.
Uh-oh.
Text messages.
Yeah.
Between the victim and this best friend. Turns out they had a huge argument just hours before everything happened. Really angry texts.
Whoa. Okay, that changes the dynamic quite a bit.
Right. Suddenly it's not just about the accused. Could someone else have had a motive? Was the friend maybe not telling the whole story about their relationship?
It opens up that possibility of an alternative narrative, an alternative suspect even, or at least clouds the picture the friend initially painted.
It completely broadens the scope, makes you question everything you just heard from her, or things really as she described.
And it highlights how investigations need to be thorough, not just zeroing in on the first likely suspect. Relationships are complex.
So true. Okay, let's shift focus a bit to the courtroom itself, the atmosphere. You have to imagine the tension, right?
Palpable, I bet. Every word, every look, scrutinized.
It's this high-pressure environment. The prosecution and defense are building their cases brick by brick.
Trying to convince the jury their version is the one that makes sense.
The prosecution's core strategy seems to be DNA plus the timeline. They're saying, look, the science puts the suspect there, the timing fits.
Building that logical chain means motive, opportunity, supported by forensics.
But the defense, they're just hammering away at the witnesses. Every little inconsistency, every change in story.
Attacking credibility. It's a classic defense strategy, especially if the physical evidence isn't airtight or has contradictions, like we discussed.
Yeah, they even mentioned the Reed trial, apparently, which, as I understand it, was famous for really focusing on witness inconsistencies to create doubt.
Exactly. If you can make the jury doubt the reliability of the key witnesses, you don't necessarily need to prove innocence. You just need to establish reasonable doubt about guilt.
And then, this happens. A huge moment. Someone on the prosecution side improperly brings up the suspect's prior conviction.
Oof. That's a major misstep. Highly prejudicial. That kind of information isn't usually allowed precisely because it could sway the jury unfairly.
The judge tells the jury, disregard that, strike it from the record.
Right. The standard instruction.
But come on, can you just unhear something like that?
It's incredibly difficult. Psychologically, that information is out there. Even if jurors consciously try to ignore it, it can linger, subconsciously affecting their judgment. It's a real challenge for the legal system.
This whole thing, it really does feel like a chess game, doesn't it? High stakes.
Absolutely. Strategic moves, counter moves, trying to anticipate the other side, all played out in front of the jury.
And the jurors are just watching, trying to figure out the truth from these, carefully constructed performances and conflicting pieces of information.
An immense responsibility, weighing evidence, credibility, arguments, trying to reach that standard of beyond a reasonable doubt.
So after all that back and forth, the jury goes out to deliberate.
And they're out for a while, 14 hours.
14 hours. That tells you something, doesn't it? It wasn't an easy decision. Lots of debate, presumably.
Suggests real division, or at least very careful consideration of complex, maybe contradictory evidence.
You can imagine the feeling in the courtroom when they finally come back. That note gets passed to the judge.
Total silence, anticipation, everything hangs on the next few seconds.
All that testimony, all the evidence, the arguments, it boils down to one single word: guilty or not guilty.
The culmination of the entire process.
So thinking about everything we've discussed, what do you listening think was the deciding factor? Was it the DNA, even with the contamination questions?
Or maybe the changing testimony of the neighbor created enough doubt.
Or the fingerprints in the glove? Or maybe that mention of the prior conviction, even though they were told to ignore it.
It's impossible to know for sure from the outside. Juries deliberate in secret. But you wonder what piece finally tipped the scales for those 12 people.
It just shows how complex it all is, getting to a definitive truth with conflicting human accounts. It's messy.
It really is. The justice system tries to create structure for finding truth, but the human element, memory, bias, emotion, is always central.
So we want to hear from you. Based on what we've laid out, do you think justice was served? Was the verdict right, or could there have been a mistake? Let us know in the comments.
Yeah, weigh in. Given the inconsistencies, the evidence, what's your take on the outcome?
Now hang on, because this isn't over. Next time, we're going into the sentencing hearing.
Right. The verdict is in, but what's the consequence? That's the next stage.
What punishment fits the crime, according to the law and the judge? Will it feel just? Could there be, more surprises?
Sentencing involves its own set of factors: the severity, the defendant's history, victim impact statements. It's another crucial part of the process.
So make sure you subscribe to the deep dive, hit that notification bell. You won't want to miss how this unfolds.
We'll break down the sentencing hearing, the arguments made there, and the final decision.
And again, tell us in the comments, what sentence, if any, do you think would be appropriate here, based on everything?
We value hearing your thoughts as we walk through these complex scenarios.
And hey, If you missed any details about the witnesses or the evidence, feel free to rewind, go back, listen again, refresh your memory before the sentencing.
Understanding the nuances of the trial definitely helps put the sentencing phase into context.
Definitely stay tuned. Sentencing is next. We'll see what the repercussions are, whether there's any sense of closure, or maybe just more questions.
Will the punishment seem proportionate? That's often a major point of discussion.
So, final thought for you to chew on. When you have accounts that differ so much, like in this case, can we ever be certain about objective truth in a courtroom? What does justice even mean when perspectives clash so profoundly?
A fundamental question about law, memory, and truth itself.
Join us next time for the sentencing hearing. See you then.